calling you and asking you and have you say, well, it's in the beneficiary declaration, and then you say, but you don't have that document. How would she know? How does she go about finding out that information?
Object to the form.
It's not a funding matter. Do you know what I'm saying? I mean, she has real concern about the information there which says Freddie Mac owns your loan. Sendlar is the servicer. Sendlar is the creditor to whom the debt is owed. And she doesn't really know, as you sit here, you don't know either. What is the difference between an actual holder versus a holder? And so the question I'm posing to you is not to be comical.
I'm not trying to be comical.
And the question is one of fact. It's not a legal conclusion. It's not for you to analyze. It's simply, if I want to know who holds my note amongst all these entities that are named in the notice of default, how do I do it?
Object to the form.
I don't know how to answer your question.
Do you don't know how to answer, or you don't have an answer at all?
Both.
So is it fair to say that within your company there isn't?
We're good here.
Sorry. On here a little bit.
This is not yours, is it?
Oh, yes, it is.
That is yours. I'll plug it in before you.
Yeah.
Start beeping on you.
Somebody, is it you who writes in different colors depending on, somebody writes in different colors? Depending on,
Warren.
maybe.
The should always come still in. Pens.
All good?
Please raise your right hand. Do you swear or affirm to tell the truth in these proceedings today?
Yes, I do.
Please say your full name for the record.
Vonnie McElligott.
Spell your last name, please.
McElligott.
Now, your formal name is not Vonnie, is it? What is
Yvonne.
it?
Is
Yvonne.
my legal name.
Okay. And that legal name would appear on your driver license, for example?
Yes.
Okay. And other legal documents?
Sometimes, yes.
Okay. Now, I understand that you've been deposed before several times, is that correct?
Define several.
More than twice?
Yes.
Okay. So you're familiar with the ground rules?
Yes.
We try not to talk over each other. And if you do not understand my question, you're going to ask, and you're going to answer audibly. Because if you keep nodding like that, she's not going to get it.
Correct.
Okay? So thank you for that. Now, I represent Leticia Lucero, the plaintiff in this case. And I want to ask you what steps you've taken to prepare for your deposition today.
When I found out I was going to be deposed, I did review the file. I did not do so right before I came.
Okay. And when was that?
Approximately 2.5, 3 weeks ago.
And when you refer to the file, are you talking about an electronic file?
Yes.
Did you happen to review any hard copies relating to the Lucero file as far as the foreclosure?
I printed out what was in our imaging to look at it.
All right. And did you keep those hard copies somewhere?
No.
Did you make any notes while you were reviewing the file?
No.
Did you talk to anyone other than your attorney in preparation for your deposition today?
No.
Did anyone give you their notes to review for purpose of your preparation today?
No.
Tell us about your employment history, starting with the most current one, Ms. McElligott.
I worked with Northwest Trustee Services for 18 years, and prior to that I worked for Bishop White. That was their name back then, for 4 years.
For how many years, I'm sorry?
4 years.
And what did you do there for Bishop White?
Basically the same function, same job.
Foreclosure business, right?
Correct.
And has your focus been non-judicial foreclosures in the state of Washington?
Yes.
Has it also been your focus, as I've learned from past depositions, that you handle Freddie Mac portfolio loans?
Correct.
Are you still doing that?
Yes.
And have you taken any more additional duties in terms of other type of loans?
I do now handle some other type of loans, yes.
What are your responsibilities for your position? First of all, what is your position?
I'm the foreclosure team manager.
Do you have another official title,
I'm the AVP.
which is Assistant Vice President?
Correct.
All right. And how many people do you supervise?
Currently 7, possibly 8. I think it's 7.
Can you name all the people you are supervising?
Yes, I can.
All right, go ahead.
Kendra Medgard, Christina Gonzalez, Elena Gorka, Rhea Preed, Heather Casey, Nicole Cleveland, and Susan Muller.
Who do you answer in terms of superior? Who do you answer to?
Alan Burton.
And what is his title?
I believe he is the Northwest Operations Supervisor.
And who does he work for?
The company,
Northwest?
Northwest Trustee Services.
And you are familiar with who Mr. Jack Stanley is, correct? What is he in relation to your position?
I believe he is Alan's supervisor.
So he is above Mr. Burton,
Yes.
and you do answer to Mr. Stanley as well?
Correct.
Technically?
Yes.
Have you received training specific to non-judicial foreclosures in the state of Washington within the last 4 years?
Yes.
And can you delineate for me what these trainings were, where you took them, and when you took them?
Object to the form.
I didn't know what you said.
Sorry, object to the form. Go ahead, answer. If you can.
Well, when the law changes, usually we have some sort of a training in regards to what to be expected, what the changes are, what we should be looking for, any new documents that have been entered into our system.
When was the most recent one that you can recall?
I do not recall.
Was it within the last 6 months?
Well, we had one, well, actually I take that back. We had one last week in regards to the new changes to the June law.
What is that? What's the June law?
Just different requirements for the servicer in regards to, and the form now that we're going to receive the lawsuit declaration in.
And what changes in the law are you referring to in terms of this training?
Object to the form. Answer if you can.
That the requirements for the lender's lawsuit declaration is going to change.
Is that a federal law, or is that state law? State law. Do you yourself provide trainings to your employees, or the people that you supervise?
Not that I recall recently, no.
But did you have the occasion to do that?
We give them directions in regards to change, but we don't actually schedule a training session specifically.
All right. In the training that you referred to, due to changes in the law, was it you that attended as supervisor capacity, or did all of your employees in your group attend as well?
I attended.
And then how did you impart your information from the training to them?
I will do so on Monday, well, today's Monday, so Tuesday. It's set up to a training session at my desk to discuss what they should be seeing coming down from the lender.
And is it fair to say that your employees look to you for directions and guidance if they have questions?
Correct.
And similarly, when you had questions or issues, you would go to Mr. Burton?
Correct.
And then at times you would also go to Mr. Stedman?
Correct.
And aside from Mr. Burton and Mr. Stedman, have you the occasion to consult with other people? For example, lawyers?
They will escalate if we need counsel.
They as in, who are we talking about?
Alan Burton and Jeff Stedman.
And these two men make that decision in that view.
Correct.
Is it fair to say that from time to time you would have the occasion to speak with lawyers from RCO
Correct.
concerning questions about a particular situation that arises.
Object to the form. You do not have to testify about anything you've communicated with your attorney.
Do you remember the question I asked you?
No, repeat it, please.
Can you read it back for her?
Is it fair to say that from time to time you would have the occasion to speak with RCO concerning questions about a particular situation that arises?
Yes.
Do you in fact consider RCO as your counsel?
Yes.
And what I mean by that is that they represent Northwest Trustee
Yes.
in general, and then you as an employee of Northwest Trustee.
Object to the form. Go ahead.
Not necessarily.
Why would they not be representing you in the functions that you have at Northwest Trustee?
I guess I make an assumption.
Okay, that's fine. So your assumption is not, or is it? Your assumption that they would be your counsel relating to your duties at Northwest
Yes.
Trustee? Did you happen to talk to Mr. Stanman at all about the fact that both of you have been subpoenaed for deposition?
I did know that we had both been subpoenaed.
You did not know?
I did know.
Okay. But did you have a conversation with him about that?
No.
Let me ask you some general questions about your function at Northwest Trustee. Does your company perform foreclosure or trustee services to a large number of banks and loan servicers?
Yes.
And Northwest Trustee receives the initiative or the command to open up a case via a foreclosure referral, is that correct?
Yes.
And this referral comes in by way of an electronic transmission via LPS.
Mostly.
Object to the form.
And relating to your Freddie Mac portfolios, is that how the refers come in?
Mostly.
And can you describe for me the process, as you know, of a non-judicial foreclosure by your company?
Object to the form. Answer.
Say it again.
Can you describe, to the best of your knowledge, the process of a non-judicial foreclosure as conducted by your company?
We're going to receive a referral. We're going to enter any information that might be missing and correct it from the download. We're going to upload any documents that the lender requires. We're going to order title. We will wait for the necessary documents to come in. We would draft a notice of default. Once all those documents have come in and any necessary ones been recorded, it will get quality control checked before it goes out. We will wait the 30 days, and if nothing has transpired in those 30 days, we would set the sale. Once the sale is set, we would check it before it goes out again. It goes to post-reward mail, and then we would additionally wait the additional time period. We would publish in between before going to sale.
When you refer to the first part of the process by which you receive the referral, your testimony is that you would verify or locate missing information. Can you
Object to the form.
explain that?
Answer to the extent that you can.
Some information comes down through the LPS load, and then if there's information that's missing that doesn't come through it, besides checking it, we're going to go find it.
And where would you go to find it?
Within the referral itself,
I see.
or recorded documents.
So so my understanding is that there's like a checklist of information you expect from the referral. Certain information that you would expect to come from the referring source.
Yes.
And when you refer to the missing information, it will be within this list of things that you would expect to see from the referring source.
No, just information that we need in order to complete our process, whether or not it comes with the referral.
So, all right, so what would be some of these informations, for example?
I don't necessarily expect the lender to provide us with all the updated assignment information. That's something we would get from title. Vesting, I don't expect the servicer to know who the vested owner is, we would get that through title.
Vesting as in past,
The current owner of the property.
right. But the lender, as I'm using your term, would provide you with vesting information at the time they give you the referral, would they not? For
Not
the sales.
necessarily.
For the sales, if the sales does take place, do they instruct you as to who?
Oh, that's two separate
Okay, so-
items.
Okay, so clarify that for me.
I meant the vesting, the current owner of the property.
All right.
You're talking about who gets title to the property after it goes to sale.
Correct. But then my question to you is that who gets the title after the sales occurs if there's no bidder?
Object to the.
That information is being provided to you at the stage of the referral.
Object to
No.
the form.
Not necessarily.
Does it vary?
In the case of a Freddie Mac file, no, it wouldn't.
What does that mean? In the case of a Freddie Mac file,
You asked who would get it when they went to sale, it would be Freddie Mac.
always,
Yes.
regardless whether there was a bidder at the sales?
You said if there was no bidder.
All right, so let me, and that's exactly what I'm trying to get at, is that when there's no bidder, it always gonna go back to Freddie, is that correct?
On a Freddie Mac file, yes, correct.
And that's an assumption
Yes.
on every file, whether you have a direct command from the referring source or not.
Object to the form.
Do you understand what I'm saying? I'm trying to get at whether this is
The
your
bidding
assumption.
instructions are normally going to say that it goes to Freddie.
All right, okay, that's what I'm trying to obtain from you. Now, when you refer to lenders, are you referring, in fact, of the entities that send you the referrals?
Object to the form to the extent that you can answer.
Yes.
And why would you call them lenders
Object to the form.
if you have a reason?
Lender, servicer, we use both words.
Do they mean the same?
In a
Object to the
conversation,
form.
yes.
I'm sorry.
In my mind, yes. Actually, no.
I'm sorry.
Well, I'm trying to think of how you're interpret. Someone servicing the loan isn't necessarily the lender, but we use it unfortunately simultaneously.
Why do you say unfortunately?
Well, I'm saying I'm not making a differentiation when I'm saying it, but there is a differentiation.
All right. So I'll ask you to do me a favor. Because this is a lawsuit and the precision of terms and words mean something important to all of us. So I'm going to ask you to be precise in your reference in your deposition today.
Okay.
It would be too much for me to ask you to do it outside of the deposition, but that's what I'm going to ask you to do. You know who Mortgage Electronic Registration System, Inc. is, don't you?
Yes.
Okay. What is your understanding of who MERS is?
Object to the form.
Is this even a MERS loan?
I'm sorry.
Was this even a MERS loan?
Well, I'll show you the documents pretty soon, but in general, do you have a working understanding of who MERS is?
MERS is listed on as a beneficiary on several deeds of trust. I do not know their working process.
At all?
Not any longer.
When did you have any working knowledge of what they were all about? Because it sounded like you knew sometime in the past.
They were just a named entity on the as a beneficiary on the deed of trust. I don't know what their inner workings are.
Have you ever talked to anybody from MERS?
No,
Have you ever received a direct referral from MERS
no,
for foreclosure?
no.
Have you, strike that, do you recall having spoken with anyone from MERS within the last 4 years concerning an issue of a Washington non-judicial foreclosure?
Object to the form.
I have received a phone call from a MERS office, I believe, because they'd received notifications of a foreclosure trying to identify the deed of trust that we were referring to.
And that was one time?
Maybe twice.
But have you ever, on your own, reached out to MERS to find answers relating to your work as
No.
at Northwest Trustee? How about Freddie Mac? Within the last 4 years working at Northwest Trustee, do you recall any occasion where you received a direct referral from Freddie Mac?
Object to the form.
No.
I understand that the LPS desktop or the LPS system is being utilized by Northwest to communicate with the referring sources. Is that correct? Is there a system separately for you to talk to Freddie Mac, for example?
To talk to them?
To
No.
communicate with them about cases that you are working on?
No, not in real time.
Do you recall having spoken with anyone from Freddie Mac within the last 4 years concerning a particular non-judicial foreclosure here in Washington?
Yes.
Okay. And do you recall what the occasion was all about? As in the nature of the communication, the questions you asked?
No, I don't.
At all? You don't have any recollection?
No, I'm trying to recollect and I don't recall what the conversation was about.
Do you know how long ago that you had this conversation?
Probably about 6 months ago.
Was it related to a foreclosure?
Yes.
And what did you do? Did you telephone Freddie Mac?
No, I believe I received an email from someone at Freddie Mac.
But as you sit here today, you have no recollection of what that is all about?
No, I do not.
Are you at all familiar with how Fannie Mae loans processed by your company in terms of foreclosures?
Object to the form.
I don't think I can speak to a Fannie Mae loan.
How about a Ginnie Mae loan?
No, not at all.
The added responsibilities that you testified to earlier, what added responsibilities have you taken besides the Freddie Mac portfolio?
Object to the form.
Would you please wait for me to finish the sentence so that it could be captured by the court?
Yes, I will. Wait for her to finish her question before you answer, and give me a second to object if I'm going to.
Do you remember the question at all now?
I do.
Okay.
I did take on just a very small portfolio from another team manager when she left, and it does include a couple of different kinds of loans, various types, conventionals. It does have some Fannie Mae in it, and some FHA and some VA, but it's a very small portion.
All right. Now, going back to your communications with MERS, first of all, do you recall whether the communication pertained to who has possession of the promissory note of the loan?
Object to the form.
No, I do not.
And regarding the contact that you had from Freddie Mac, do you recall whether it was relating to the question of who had possession of the note of that particular loan?
Object to the form.
No, I do not.
Do you recall at all ever having a conversation with either Freddie Mac or MERS relating to who has possession of the note in a particular loan?
Object to the form.
I know it's long, but if you...
No, I do not.
Well, before we get into this case, I want to give you an opportunity to set some boundaries or working knowledge. So what I will ask you today, unless I specify differently, Ms. McElligott, these assumptions can apply to all the questions that I'm going to pose to you. Okay? First of all, you're going to assume that I'm only asking questions about deeds of trust in which Northwest was never named as the original trustee.
Okay.
All right? Which means that Northwest comes in as a successor trustee. All right? And the other, and this next assumption that I am going to give you is that these are deeds of trust that have MERS as a nominee. All right? And I'm also going to ask you to accept the assumption that the questions I'm posing for you here are relating to cases where the original lender is not the same entity that's referring the foreclosure. Does that make sense? All right. So with those assumptions in place, I'm going to ask you to define for me certain terms. And when I ask you to do that, I really want you to talk about your working knowledge. You may personally have some understanding about what these terms mean outside of your work. I'm confining you to the knowledge that you need to do your work on a day-to-day basis. Does that make sense to you?
Yes.
Okay. Just in your testimony a few minutes ago, you talked about the fact that you refer to lender and servicer sometimes interchangeably. You remember that?
Yes.
What is your working definition of what the lender is?
Object to the form.
In the terminology I'm using it in the sense that they lent the money, or they are owed the money.
Okay. So with that, what is the servicer?
They may not necessarily be owed the money, they may be servicing the loan.
Which means what? They collect money on behalf of the entity that is owed the debt.
Correct.
And what is your working definition of an owner of the loan?
Object to the form.
That would be the holder of the note. No, I'm sorry. See? The
Go ahead.
owner of the debt, not necessarily the holder of the note.
So is the owner the same as the lender?
Object to the form.
I don't know.
Your testimony about the holder of the note, what is your working definition of a holder?
Object to the form.
The one who holds the note?
In a physical sense?
Object to the form.
Yes.
In real time? Are there any other definitions that you have concerning the holder?
Object to the form.
No.
Have you heard of the term the actual holder
Object to the form.
Yes.
in your business? You have?
Yes.
What does that mean to you?
The one who actually holds the note is in the beneficiary declaration at one time.
Okay, so I'm going to need you to clarify that for me. You're referring to a verbiage within the beneficiary declaration?
Yes.
Okay. And are we talking about beneficiary declaration as a form that is being or is prepared by Northwest Trustee?
Object to the form.
Often, yes.
And so you're referring to the verbiage being used by Northwest Trustee in the beneficiary declaration.
Yes.
And Northwest drafts these beneficiary declarations and send them out according to the process you described, correct?
Object to the form.
Often.
And the term actual holder appears on one of these beneficiary declaration forms in the past.
Correct.
Object to the form.
Do you know the time frame when the term actual holder appeared in the beneficiary declaration form that we're talking about?
I do not.
Okay. And was there an event that occurred that caused that term not to be used any longer?
Object to the form.
I honestly don't recall what the situation was
At all?
at all.
Okay. You just know that that term is not being used currently?
I don't
Object
believe,
to the form.
I don't believe so.
What is your working knowledge or definition of what the beneficiary is?
Object to the form.
The holder of the note.
Is it the actual holder?
Object to the form.
I don't know.
You don't know at all whether the beneficiary has to be the actual holder?
Object to the form.
understand that I'm not giving you a test. I'm asking for your actual knowledge. Do you know what I'm saying? I'm not giving you a test. This is not a test. I'm asking you for what you actually know.
Well, then I don't know that they are the actual holder, except for the fact that they signed a beneficiary declaration saying that they are.
Excellent. That's exactly what I need. Okay? Because you don't have to rely on something that you don't know. Okay? And then the next term I'm going to ask you to define for me is the creditor to whom the debt is owed.
Object to the form.
What does that mean in your mind?
I don't have a definition for that.
It means what it says. Would you agree? The creditor to whom the debt is owed.
I don't know.
You don't form an opinion about that.
I don't.
To the best of your knowledge, is there somewhere in the policies and procedures of your company, Northwest Trustee, that the terms are defined in writing?
Not that I recall.
If an employee of yours comes to you and asks you, who is the beneficiary in this loan, what would you tell that person?
Who signed the beneficiary declaration?
And that will be the instruction you give that person.
I would actually look more further and ask who we were asked to foreclose in, who signed the beneficiary declaration.
And is there a relationship between these two entities, the one that refers and the entity that signs the beneficiary declaration?
Object to the form.
They should be the same.
And aside from the beneficiary declaration and the information that is given to you by the referring source, can you think of any other places that you would go to ascertain who the beneficiary is?
Say that again.
Can you read that back?
Yeah. And aside from the beneficiary declaration and the information that is given to you by the referring source, can you think of any other places that you would go to ascertain who the beneficiary is?
We can look for assignments, but it's not required.
Assignments of deed of
Deed of
trust. And where do you go look for that? In the public records?
With the title report, yes.
And when you say that you are not required, can you elaborate for me?
There's no requirement that an assignment be a record.
Okay, and that's by law that you're referring to.
Correct.
And so even though it's not required, you would rely on it to ascertain who the beneficiary is.
It would be a backup to support.
It would be that.
Backup?
So why would you need backup? Give me a scenario where
You asked me to look for if there was another source that we would look to.
Okay.
We could look there.
Okay. Anywhere else that you can think of?
Not off the top of my head right now.
Now, at any times that you have questions about how to determine who the beneficiary is and whether or not the information being referred to you are accurate, do you consult with your attorneys for answers?
I don't see why we would need to.
So long as you have the information from the referring source and the beneficiary declaration, you're comfortable proceeding with your work.
Yes,
Is that fair to say?
Yes.
And the occasion when you have to go and look at the assignments, once you are able to ascertain the assignments, answer your questions, that way your inquiry ends.
Object
Is
to the
that fair
form.
to say?
Object to the form.
Yes.
asking you to look at Exhibit 1 and take a few minutes to look through it and tell me whether you recognize Exhibit 1.
Yes.
What is Exhibit 1?
It's the deed of trust.
Relating to my client's case, is that correct?
Correct.
And I'm going to ask you to refer to page 2 of Exhibit 1 under paragraph C. Do you see that?
Yes.
Can you tell me who the lender is identified by Exhibit 1?
Taylor, Bean, and Whitaker Mortgage Corp.
Do you have any idea whether this entity is doing business?
I recall that they had filed bankruptcy.
Do you know when about they filed for bankruptcy?
I do not.
Is it fair to say that they had been out of business at the time that this foreclosure was initiated by your company, which is in 2012?
I don't know if they were out of business or not.
Do you see under exhibit, do you see in Exhibit 1 under paragraph E that MERS is being identified? Do you see that?
I do.
All right. And does that lead you to believe that MERS is the beneficiary under this particular document?
Object to the form.
Yes.
Does your company rely on this deed of trust to initiate the foreclosure on the Lucero property?
Object to the form.
Yes.
And I'm going to refer you to, and by the way, have you ever read through Exhibit 1?
Through this particular deed of trust, word for word? No.
Okay. Any other deed of trust that you have read through in your business?
Years and years ago, yes.
And does that, am I to take it to mean that you don't read the deed of trust anymore for the contents, even though your company relies on it?
We look for some agricultural clauses. We make sure that it's got the power of sale. We do review the deed of trust for those particular items.
So you look selectively for the information that you need.
Correct.
In doing so, do you know under the deed of trust, and this will be, I represent to you, this is a standard deed of trust. What is your understanding under the deed of trust language? Who can declare a default on the borrower?
Object to the form.
I have not read through the deed of trust enough to recite that to you.
But do you have any general understanding as to who can declare the borrower in default under the language of the deed of trust?
I haven't read the deed of trust in a while. I don't want to say when I'll be wrong.
All right, okay. Well, let me refer you to page 13 of Exhibit 1. And I'm going to ask you to look at paragraph 22, the bold-faced prints. Do you see that?
Oh, sorry, I was going back to where it talks about the lender. I'm sorry.
Sorry,
say it again.
page 13,
Yes.
paragraph 22.
Yes.
Can you take a minute and read it and tell me who declares default?
The lender.
So according to the deed of trust, it would be Taylor Bean Whitaker, would it not?
Object to the form.
I'm asking.
If they were still the lender of this deed of trust specifically.
Yeah. Ms. McElligott, I'm asking you to look at Exhibit 2 and tell me whether you're familiar with Exhibit 2.
Yes.
Where did you see Exhibit 2 before coming into your deposition today?
Object to the form.
In our electronic system.
Do you recognize Exhibit 2 to be a pertinent document to the foreclosure of the Lucero case?
Object to the form.
Why, I'm sorry, why are you objecting to the form again?
Every single question that you're asking is leading. It's trying to characterize or mischaracterize testimony that she's given. Ask her the questions and let her answer them.
No.
Don't testify for her.
Okay. And I'm not testifying for her. If I'm asking you a question and there are parts of it that you don't agree, please tell me. Do you understand what I'm saying? Because her objection is that I'm putting words in your mouth, and I'm not trying to do that. So if you listen to my questions carefully, you say, okay, that part is not what true, or that's what not what I'm saying, then tell me that.
Okay.
All right? So let me ask you the question again. Do you recognize Exhibit 2 to be a document relating to the Lucero foreclosure?
Yes.
And what is Exhibit 2?
The note, copy.
And what purpose does it serve in your conduct of the foreclosure on the Lucero property?
Purpose. Define your definition of what purpose.
What is your reliance on the information that is contained in Exhibit 2 in order to do your work in the foreclosure of my client's property?
We want to see a copy of it in our file
Why?
for review
Of what information?
to make sure that we have an image of it. The loan amounts are the same, that the document matches the deed of trust.
Excellent. So who gave you a copy of Exhibit 2?
I don't know.
But you do recall that it was part of your file? Please say yes.
Yes.
Now, with that, I'm going to ask you to refer to the first page. And if you look under paragraph 1, borrower's promise to pay, did you see that?
Yes.
And I would like for you to read that sentence that begins with, I understand that the lender may transfer. Could you read that entire paragraph?
I understand that the lender may transfer the note. The lender is, or anyone who takes this note by transfer and who is entitled to receive payments under this note is called the note holder.
Do you have any doubt of that language saying what it said, what it means, or meaning what it says? Strike that, and let me put it to you this way. Do you have any reasons to dispute that particular paragraph as contained in Exhibit 2?
Object to the form.
I don't have any reason to dispute it.
You testified earlier that after receiving the referral, you would confirm information and then prepare a notice of default. Is that correct? I'm asking you to review Exhibit 3, and please identify if you recognize Exhibit 3
The notice of default issued.
in the Lucero case.
Correct.
And I want to first ask you to look at the exhibit under paragraph D And even though the pages are not numbered, that would be the second page. Paragraph D. Do you see that?
Yes.
Can you tell me where, well, first of all, do you recognize the exhibit as something that you were involved in? The preparation, the information being collected there?
It came from my team, yes,
And you know that because what?
because my name is on the notice.
Okay, that appears on the last page?
Correct.
So let me go back and ask you to look at the paragraph D. And I want you to tell me how you or your team came about collecting the information for the delinquent monthly payments, as stated there.
The information would have been received on the referral document.
From Senlar in this case?
Yeah.
Okay. And that information was received by you via electronic means?
Correct.
How about the late charges there? Did it also come from Senlar?
Would have been on the referral
How about the lender's fees and costs?
or part of the referral.
Okay. Do you see the parentheses there?
Yes.
Do you know why? Does that mean that there's a negative there, or why is that figure contained in?
I would have to guess
What would be your guess?
that there might have been a suspense account, suspense amount held in suspense.
And what does that mean? Not applied to the loan?
Object to the form.
Yes.
And the reference there of lender's fees and costs, is that a term that is decided by Northwest Trustee? Do you understand my question?
It is part of the template of the document itself, which I believe is written per the statute. I'm not quite sure where the lender's fees and costs wording is derived from.
Right. But this is the template that your company uses time and time again, correct?
Correct.
Okay. So let's go down to the next line, which says trustees' fees. Do you see that?
Yes.
Okay. And the amount of $542.50. You see that?
Yes.
By looking at the exhibit, the notice of default, does that mean that the trustees' fees are assessed or added on to the overall amount needed to cure?
Yes.
So I know your testimony, this is a template being used by your company, but what specific trustees' services being provided at this point in time for the notice of default?
You're not sure I understand your question.
Okay. So this might be helpful. If you go to the last page of the exhibit, not the last page, the third page, where your name appears. Do you see that?
Yes.
All right. And do you see where the date of the document appears?
Yes.
And the date is when?
August 27, 2012.
And you see to the right of that, there's a designation that that Senlar FSB is responsible for this notice of default. Or that.
Senlar FSB is named.
Okay. And then the notice of default is issued by your company, correct?
Correct.
In the capacity of what?
And it's duly authorized agent.
For Senlar.
Correct.
Okay. So let me go back to my previous question. And my question is under D, when my client is charged or assessed a trustee's fees, what trustee services will be provided by August 27, 2012?
The drafting of the notice of default is what the fee is for.
Okay. And that is being labeled by your company as trustee's fees, correct? All right. So let's go down to the costs. And do you see where the notice of default states title report?
Yes.
And in parentheses, it says estimate. Do you see that?
Yes.
So tell me why that was an estimate instead of an actual cost.
Oftentimes it's ordered and we don't have the actual title report in at that time, and so we estimate what the cost is.
Okay. So $890 is the estimated cost.
Correct.
And who would be receiving the fees for rendering the title report?
Object to the form.
Who gets that money?
The title company?
And in this case, do you know who it was?
I do not.
Under cost, there are also certified mail. Do you see that?
Correct, yes.
And is that cost paid to your company?
That cost is paid to the U.S. Postal Service.
Okay. But your company is responsible for mailing it out?
Correct.
All right. How about the posting fees?
How about them?
Who gets that money?
The posting company.
And who is that?
I would assume that it was FEI.
And that is a company that is an affiliate of Northwest Trustee?
Object to the form.
I'm sorry, what was your answer?
Correct.
I am going to ask you to refer next, Ms. McElligott, to paragraph K. Do you see that?
Yes.
Okay. And under paragraph K, your company provides information for note owner and loan servicer, is that correct?
Yes.
And who's the owner?
Federal Home Loan Mortgage Corporation.
Also known as Freddie Mac?
Correct.
Okay. Can you tell me why there was no phone number for Freddie Mac being given here?
I cannot.
And then Northwest also disclosed to my client the loan servicer for the loan is Senlar, is that correct?
Correct.
All right. Let me have you flip back to page 2, paragraph C. Do you see that?
Yes.
Paragraph C, as we see here, is the declaration of payment default. Do you agree?
Yes.
What does that sentence read?
The beneficiary declares you in default for failing to make payments as required by your note and deed of trust.
Take a moment and look for me and tell me where the beneficiary is being identified in this exhibit, the notice of default.
The beneficiary does not appear to be identified.
I'm asking you to refer to the last page of the notice of default, under paragraph L.
Yes.
Do you read that? Now, paragraph L tells us that this is a notice that Northwest Trustee provides to my client pursuant to the Federal Fair Debt Collection Practices Act. Do you see that?
Object to the form.
Yes, I see that.
All right. Is it your belief that this notice is required to be given by Northwest by law?
Object to the form.
I do not know.
Does this paragraph appear in notices of default besides my client's own notice?
Yes.
I'm going to refer you to sub 2 of paragraph L. Do you see that?
Yes.
What does it say?
The creditor to whom the debt is owed is Senlar FSB.
And in preparing the notice of default, exhibit 3, who decided that Senlar is the creditor to whom the debt is owed?
We would have received instructions to foreclose in the name of Senlar, and we received a beneficiary declaration signed by Senlar.
And that's why Senlar appears right there in the line that you just read.
Yes.
Your testimony regarding a beneficiary declaration that is signed by Sandlar, correct? You don't have that in front of you, do you?
The beneficiary declaration
Right.
signed by,
By Sandlar.
you mean the copy?
Well, look at that again and tell me if that is in fact a beneficiary declaration.
Oh, sorry, this is the loss amount declaration.
All right, okay,
Correct.
yeah, so just we can be straight about that.
Correct.
So let's talk about the foreclosure loss mitigation form there, which is attached to the notice of default. Is this form attached to every notice of default?
No.
Okay. Do you know under what circumstances it would be attached?
It would or wouldn't?
Would or would not? What I'm trying to get at is when or how my client would get this loss mit declaration.
It's attached.
Object to the form.
I think there were 3 questions there.
Tell me normally, or in the practice of your company, how does this form fit in? Did it get sent to my client simultaneous with the notice of default?
Yes.
Object to the form.
Yes. It's attached to the notice of default.
Okay, so as it appears here is what my client received when she received the notice of default, correct?
Yes.
Okay. And how many copies of the notice of default does Northwest send out generally in a particular foreclosure?
Object to the form.
I have no way to give you an average of how many notices of default are sent.
No, I'm sorry. When your company sends out a notice of default to a particular borrower, does your company not send more than 1 copy?
We're going to send 1 certified, 1 regular to each and every known address, and we're going to physically post 1 to the property.
All right, okay. So as you're referring now to the foreclosure loss mitigation form, what are the purposes of this form?
Object to the form.
Define purpose.
Your company attached it to a notice of default,
Correct.
which was sent out to my client.
Correct.
Was it done for a purpose or arbitrarily?
Well, the loss mitigation form is a requirement.
Okay, by law,
Yes.
which is what, the Washington Deed of Trust Act?
Yes.
And I want you to take a look at the loss mit form. What is the date of that document?
It is dated August 14, 2012.
And it is your testimony that this was signed by Sandlar?
Object to the form.
To the best of my knowledge, yes.
Why did you say that?
I have to assume that it is signed by someone.
Why would you assume? What basis? What is the basis of your assumption?
That the document says it's Senlar?
The
Yes.
letterhead, correct?
Yes.
Okay. Can you tell me down below, though, by the signature, can you make out what that signature says?
I cannot.
Do you see a title for that person who signed?
I do not.
All right. So the basis for your conclusion that it has to come from Sandlar is because it is on Sandlar's letterhead. Is that correct?
Correct.
All right. So as of August 14, 2012, based on this assumption that you just testified, Sandlar was acting as the beneficiary at that point on that date?
Object to the form.
Or do you know?
Object to the form.
Why would you object to that?
Your questions are so confusing. I don't even know what you're
It's not
asking.
Counsel, the questions are not intended for you. If the witness understands, she can answer.
Well,
And
I
I would
can object
appreciate
if
that
they're
you're not
confusing.
taking that time to make an objection that is not relevant.
Well, I would appreciate if you would ask clearer and concise questions so that she
Again.
can answer them.
Counsel, the questions are not
I'm
intended
entitled
for
to
you.
object. And, well, I'm here.
Why do you assume that she doesn't understand my questions?
I am entitled to object if they are confusing, if they are compound, if they are leading. I can object on those grounds.
And what I'm saying to you is that unless she tells us that, you are being obstructed because you're interjecting an objection every time.
Not
Even
every
a simple
time. I'm
question.
sorry if you're having trouble constructing clear questions.
I
That's
would
not-
object to that. That is very insulting. I don't appreciate that comment. That witness hasn't told me that she couldn't understand my question. And when you presume that I don't have the ability to frame a question, I resent that.
Well,
So again,
I'm entitled to
let me
object,
say
which
it
I
one
will
more
continue
time.
to do if your questions continue to be confusing,
One more
compound,
time.
misleading.
Counsel, one more time. The questions are not directed at you. Whether you understand them or not, it's not relevant. If the witness cannot understand, then
I
your
am entitled
objection,
to object.
you're not entitled to object every time.
Well, I'm entitled to object on those grounds. So if the questions fit into those categories every time, I am entitled to object every time.
If you are not doing this in good faith, I'm gonna
There is
have-
no reason that you should suggest I'm not doing it in
You're
good
not
faith,
doing-
and
you are not
resent
doing it in good
that.
faith. You just insulted me by saying to me that my questions are not understandable by you. And my question back to you is that they're not intended for you. So unless you're saying to me, you know, these questions are completely obscure and this witness is unable to answer, which not the case.
Your questions are obscure. They're not
To
clear.
you, which I already indicated how I react to it. I think it's completely insulting for you as a lawyer to insinuate that I don't have the ability to formulate a question for you to understand. Setting that aside, I'm going to ask the witness the questions
Okay, but
that
she
she
is
can
not
understand.
going to object. I will be the person objecting. So let's go forward. Please try to devise your
What, speak
questions.
better English? Frame better questions?
That is not what I said.
That's what
Frame
that's-
better questions.
That-
Yes.
Okay, that is how I perceived it. Because now that is the insinuation that I have. Every question I pose, you interject an objection. And what I'm asking you to do is have the courtesy to allow the witness to say, I don't understand that question,
Well,
or that it's so compounded.
I have to object in order to preserve the objections. So I'm doing my job, okay?
I'm asking you in good faith. If you don't have a basis, don't do this because it's costing me money.
Well,
it's
I'm not
costing my
objecting
clients
where I
money.
don't have a basis. So for you to insinuate that I am objecting where I don't have a basis is equally as
I'm not
insulting.
insinuating. I'm telling you how I perceive your objections. Okay?
Okay,
What
well,
you intend. I
perception
can't-
is everything, and
Wow, it's not just my perceptions being captured. So in any event,
okay.
could you go back and read me the last question?
Pardon me, one moment. We just crossed the 1 hour threshold, and I tend to take a break every hour if there's not a natural break. So we'll
All right.
walk the
So
record for one moment here at 10:04 a.m.